Hello everyone, I'm Frondorf, a research fellow at UC Hastings, and I'm joined today by Professor Feldman to speak about our new paper on patent demands and initial public offerings, and it's an early empirical study of patent demand timing. I want to start with an illustrating example back from 2002, when towards the end of the first dot-com boom, or really after the first dot-com boom, PayPal was one of the few successful tech companies to make it to the IPO stage. But just days before their 2002 IPO, they were hit with a lawsuit from CertCo. CertCo alleged that PayPal had been infringing their patents for over 2 years, but sued only 3 days before their IPO. And PayPal, in their countersuit, alleges this was done to disrupt their IPO. And that's exactly what happened. The PayPal IPO was actually delayed for over 2 weeks, causing untold damage to their share price and reputation. This is not a news story. We have a Globe and Mail article here from 2012 showing that in the year running up to its IPO, Facebook was sued over 20 times for patent infringement. And it's a story that's been told many times over the last decade between Google, Twitter, OpenTable, Grubhub, all seem to have been victims of pre-IPO lawsuits. There was even a plot line this season on HBO's Silicon Valley where the company is sued before it's about to receive its first initial funding round. So our study is one of the first quantitative looks at this issue to show, does an actual pattern of targeting behavior emerge? We have all of this anecdotal evidence that companies are sued either right before or right after the IPO, but is this really actually happening in practice? Are monetizers or NPEs really targeting companies for demands near their major funding rounds? And our hypothesis is that monetizers are focusing their activity around these funding moments, such as the first venture rounds, the Series A, the Series B, and the IPOs, taking advantage of the different vulnerabilities and economics of the funding moment. And there is some related evidence to support this. A very recent paper from Cohen, Gruen, and Commoners found that a firm was 50% more likely to be sued by an NPE following a large positive cash shock. And obviously an IPO would be a classic example of one of those large positive cash shocks. They also found that those cash shocks were a good indicator of the number of times a firm would be sued by an NPE. And finally, and perhaps most importantly, they found that these results held only for NPEs and not product companies. Thus, you're only likely to get more sued by an NPE if you had a large positive cash shock, not by a product company. So for our study, we collected information on all US product companies that went public between 2007 and 2012. That's about 550 companies in that time frame. And then we found contact information for normally the general counsel, but other in-house legal contacts at most of these companies, about 400 of them. And then distributed a survey to each of these companies asking about their exposure to patent demands at some different stages. Did you receive a patent demand before your first funding round, before your IPO, and the year after your IPO? And you might ask at this point why go with a survey-based approach rather than use some type of litigation database that would have more explanatory power. But with patent demands, as you might be aware, many of it takes the form of letters, threats, different approaches that really aren't official. So most of this activity, as much as 90%, isn't reaching the litigation stage. So while surveys are a flawed approach that have their drawbacks, they're really the only way to get a good scope or a good idea of the full breadth of activity that's going on. And so that does bring up some of the limitations with any type of survey like this. We had a low response rate, about 50 or so companies responding, which if you look at it one way, that's about 10% of all the companies that went public during our time frame. But it's still small, and it introduces the possibility of a non-response bias. And some of our checks for representativeness to see if our sample population was similar to the actual population in terms of their IPO year, what sector they came from, what was their annual revenue. We found that it was generally similar. So at least on its face, the sample seems representative, but there's definitely some limitations, and so we stress this is just a preliminary look, an early look at patent timing. So to jump into the results here, first just to show what sectors the companies responding to the surveys came from. The majority were from information technology and the life sciences. And that's not particularly surprising. The majority of companies going public these days are in that field. And so our first question, we asked if companies receive patent demands, which we defined as not just litigation, but also letters, licensing requests, other demands that companies feel they had received from patent holders. And we asked if they had received demands prior to receiving their first venture capital round. And here we found not really, only 4% or 2 of 50 had received patent demands at this point. And even after, in the year after receiving the first venture round, the proportion was still very small. So there's no real evidence that this timing activity is happening near the first venture funding rounds. Only 8% at this stage said they had received a demand. But as we jump ahead to the IPO periods, we asked if they received patent demands, if these companies had received demands between filing the S1 and actually completing the IPO. And here we do see an uptick in the activity, around nearly 20% receiving a demand at this stage. And that's particularly interesting just because of the brevity of the period between the S1 and the IPO. It's usually, as you might be aware, the S1 is the form you file with the Securities and Exchange Commission declaring an intent to go public. And it's usually only about 12 to 16 weeks from filing the S1 to actually completing your IPO. So that's a number of companies receiving demands in a pretty short period of time. And then after the IPO, once that large positive cash shock has taken place, we see the numbers increase once again with over 30% of our companies receiving a patent demand at that stage. And then, if you combine the two periods, asking, did you receive a patent demand either in that period between the S1 and the IPO, or in that year after completing the IPO, making sure not to double count for those who received demands in both periods. We had 40% of our companies receive patent demands at this stage, so a pretty significant proportion. And then there's some interesting cross-sectional data that we can look at from all 4 periods that we measured. This one asks how many patent demands, if you had received one, did you receive during that period? And you can see in the first venture round stages of before the first venture round and the year after, few companies had received demands, and even if they did, they were only receiving 1 to 3. But in the pre-IPO period and the post-IPO period, it becomes a lot more interesting, especially the year after the IPO, where 50% of our companies received 4 or more demands if they had received one. And then finally, we asked, to the best of their knowledge, what type of entities issued the demands during each period. And you can see that product company activity, which does occur, was pretty low and remained at the same level throughout the 4 periods of our study. But monetizer activity increased sharply, especially in that year after the IPO, where an overwhelming majority of the demands were issued by monetizers. And then finally, just to carve out one specific section of our study, we wanted to look specifically at tech companies, since evidence shows that they're overwhelmingly affected by monetizer demands and patent demands in general. And here we see that in either the pre-IPO period or the post-IPO period, almost 60% of the tech companies, admittedly a small group, just 10 of 17, said they had received a demand at this stage. And with that, I will turn it over to Professor Feldman to go over some of the implications.
Thank you. Oh, that's good. All right. So let me take you quickly through what I think is the key progression in the results graph. Let's see if I've got this working. And these are from the full results, not the results that are industry specific. So this is prior to the first funding round. This is the year after the first funding round. This is between announcing the IPO and going public. This is the year after going public, and this is combined between announcing the IPO and the year after the public. So one can see clear contrasts in these periods. And in the last part of the paper, we tried to hypothesize what might be happening that could lead to these results. And we came up with 3 possible theories. The most straightforward is what we call the full pockets theory. There's an influx of capital in the IPO period, so the company is flush with money. I'm sorry, I sat in on the copyright section yesterday and I got to watch Beyonce videos, and I figured we in the patent could come up with one interesting image. All right. Companies flush with money, so think of Sutton's Law, which cautions doctors to first consider the obvious when making a diagnosis. Sutton's Law is, by the way, apocryphally based on a supposed quote from a bank robber who, when asked why he robbed a bank, said, because that's where the money is. So certainly a company with newly full pockets might appear to be a good target for a lot of things, including patent demands. The theory fits well with our observation that more companies received patent demands after their IPO than shortly before their IPO. Another piece of support for the full pockets theory is the fact that the vast majority of respondents who received demands in the year after their IPO had annual revenues over $50 million. In other words, these were big targets. In contrast, other scholars such as Chen and Besson and Moyer have found that on the whole, non-practicing entities direct patent demands at smaller companies. Thus, it may be that non-practicing entities are augmenting their general strategy by attacking high-value targets around the IPO, or that some NPEs are focusing specifically on the IPO segment of the market. A second theory is what we call leverage theory. Patent demands are coming around the IPO because that is a key point of vulnerability, and targeting pain points is an excellent way to obtain maximum leverage for a payment always. Specifically, an IPO is one of the most public and vulnerable times in a company's development. It requires extensive disclosure of information to win SEC approval and to woo investors. That's true not only right before the IPO, but also in the aftermath, because that early period of trading is important for cementing a company's reputation and its all-important stock price level. So all of this scrutiny makes a company uniquely sensitive to anything that could affect the company's valuation. From this perspective, one can make an analogy to the near-universal litigation that arises at the time of corporate mergers and takeovers. For example, Kane and Solomon found that almost 95% of large merger deals in 2014 experienced litigation. As they concluded, if a target announces a takeover, the company should assume that it and its directors will be sued. Other scholars have documented that mergers are a classic example of a pressure point that could lead to a company to a less than optimal settlement to avoid contingent liabilities. Similarly, a company's wish to avoid contingent liabilities during the IPO scrutiny may push a company to settle and supersedes the merits of any claim. As an aside, every time I write one of these papers, I worry that all I'm doing is publishing a roadmap with a big flashing neon sign that says, this way to quick and easy money. But do the best I can. So the final theory is a little more cheerful. It's what we call the visibility theory. And this theory hinges not on the economics of the IPO moment, but on information asymmetries that may be bridged by a company's IPO. In particular, the publicity arising from an IPO could make a patent holder aware of a potentially infringing company. Alternatively, the SEC disclosures that are made public could give the patent holder information necessary to determine that infringement is taking place. Thus, the visibility theory could provide an explanation for legitimate patent claims near the IPO. However, if this theory were the dominant explanation for the observed behavior, we would expect both non-practicing entities and product companies to increase their demand activity near the IPO. Both types of market actors should benefit from the information access that's increased during a target's IPO. In our limited sample, however, product company demand activity remains consistently low throughout all of the periods we sampled. And in contrast, NPE activity starts low and then rises sharply during the pre- and post-IPO periods. This suggests that the visibility theory is not the dominant explanation, although it could play a role in some of the cases. Our intuition is that a complete explanation likely combines all of these theories: deep pockets, leverage, and visibility. Thus, these observations taken together push against what we would call virtuous, innovation-boosting or inventor-protecting explanations for patent demand activity in the segments of demands we were observing. This suggests that in this segment, patent demand activity by non-practicing entities is driven not solely by the legitimacy of the claims, but by the status of the target company and the economics of patent litigation, which, from an economic perspective, is less than optimal for the patent system. So for the question time, I'm going to give the lead to my junior colleague, Gavin.
Yes.
Hey, so this is a really interesting and important line of inquiry. And so I've got mostly kind of methodological questions for you. And so number one, so you used a survey, which is kind of a counterintuitive, odd way to get this kind of data, but which you could make work. But why not survey prospectus disclosures? Why not use the documents? Why not use the amendments to the prospectus after litigation is filed?
Yes, when they would acknowledge that they had, in their risk factors section, acknowledged that they received a lawsuit.
And they probably would have talked about the lawsuits from pre, the VC round lawsuits also.
Well, I think part of that goes back to how much of the demand activity is taking place outside of a lawsuit or outside of litigation in terms of just letters you receive or requests you receive or settlements that you enter into without even entering the litigation stage.
Yeah, okay.
The prospectus requires that it rise to a materiality level. Patent demand that's received before you've received your first round of funding and that you've settled would be very unlikely to rise to a materiality level at an IPO. And
right, and so that leads to the next question, which is how do you have any filter for materiality, right? A demand from Innovatio for $2,000, well, it might seem, not nice, who cares, right? It has no impact on the actual finance of the company. So it'd be interesting to see some data about the magnitude of these demands are, because if they're all trivial, then this is much less interesting data than if they're all for, tens of millions of dollars.
There's data, there's some impact data in the study if you look.
Okay, that's good. I also know there's some big time gaps, right? I mean, you've got the first round of financing, like a year after the first VC round, and then the day the S1 is filed, a huge time gap in there. And, the knowledgeable NPEs, everybody knows when a company is going to go on file, right? Mm-hmm. So what about the 6 weeks before the IPO?
No, I think that would be very interesting to look at further. We were actually talking about this very thing just a couple days ago.
Yeah, I mean,
to explore more of the periods. Exactly.
I mean, the hold-up story is the most interesting story here, right? I mean, the post-IPO, the deep pockets question, then you just, I would want to see some comparisons about how the litigation rates here compare to the overall industry litigation rates, because now these companies are just part of the public company pool. The same as Cisco and Apple, they've got much deeper pockets than some, newly public company. And how do the rates vary? Are they any different, right? The hold-up story is kind of the most interesting and unique one here for this market.
I think but you have to factor in, you're right, given infinite number and the infinite patient ability of people to answer survey questions, which I've learned is limited, the longer, the lower the response rate. But you have to, so if you look industry-wide, you have to factor in the sensitivity of that post-IPO period for market setting. So that is, in the securities world, that's a sensitive point. And so
sure.
you can't compare a post-IPO to Apple or to Google. They don't care because their stock price is set. It'd be a very different kind of shock to affect Google's short-term or long-term price at this point than Google's short-term or long-term price in the year after they went public.
So that's an extension of the hold-up story in the post-IPO phase.
Exactly.
Right?
No, but that's a study design issue. That's why it's worth looking at that immediate period, even if we don't have the luxury of having everything from everybody everywhere.
Sure. But as far as the deep pockets theory, I mean, that, it just blends in with everything else. And the final point is the sample size. I mean, I guess I'm just curious what sort of statistical strength analysis you've done. I mean, 17 tech companies over what time period, and out of a sample size, out of a total pool of how many?
Yeah, I would say the sample size was limited. and I would stress that it's just an observational look, that I don't think I would assign any statistical significance to it really much at all, but I would say that observationally it's very interesting and it's a good early look for next steps.
I think even with a study like that, I mean, unless it's just
Or the pool's you asked how the pool's 500. 500 companies went public during this period.
Okay, yeah, that's the question. So 17, or so 50 out of 500.
No, 50 out of 500.
Yeah. Okay. Okay. No, I mean, you know, I think these are minor points. I think it's great.
Oh, sorry.
So I guess just to clarify, I think I'm following up on that. So was there any normalization for just the general litigation increase during an IPO period for all sorts of litigation, employment, torts, things like that?
That's actually that's not something we explored, but I think that would be very interesting just to look at the overall.
Has there been previous work on that to see that there is a general litigation increase for lawsuits during that time period?
Yeah, I think there is some data, and I would assume that it's consistent, and it's also consistent with the explanations, both the leverage and deep pockets. In other words, my guess would be, without having deeply studied that literature, my guess would be that this would probably fit into the overall model of pain points during particular times. This now becomes a new method of pain points during that period.
Just one question I have, just in terms of the deep pockets, why should that be viewed as anything suspicious or nefarious? I mean, it doesn't seem to make sense to say we should say patent holders should engage in wasteful litigation where they can have no gain. Innovators who help generate these patents can have no trickle back gain because they're suing companies that have no money. So I mean, the leverage explanation can be viewed, I think, as something that's necessary. Could be viewed as a kind of strategic behavior that we might view as negative. I think more naturally, the deep pockets where you might say this is just sensible behavior, picking suits and targets for suits that could actually generate some money at the end of the day.
I think that while that may be the case, I think with patent, it shows that it's not just the validity of the claims that's determining the timing of the suit. That part of it is the fact that they have money at that stage, and I don't know if that's as benign as it might be assumed to be.
The question for model patent design is simply, what do you have that is based on the merits of a patent claim, and what do you have that is not? And do you appear to have a body of behavior that's not based on the merits of the claim? And when you have that, then you have some optimal patent design.
I don't think that's right. I mean, I don't think you would say. I think it would be absurd to say, well, you should be suing because even though you can get nothing from this suit, you have a very strong, you have a dead-on infringement claim, and your patent is completely secure. I mean, I wouldn't think we would expect or necessarily want that behavior. And this goes partly to why I think Colleen and Michael were concerned about suing smaller players. Problems that can create. I mean, I just don't see that. There are many violations. Someone can walk on your lawn, and that's an obvious trespass. You'd be bringing suit against them for that. I don't think that would be optimal for our society, even though it might be a dead-on legal claim.
So I think you're hypothesizing that the deep pockets is just a timing of when you think you will be better, but it may be a legitimate claim. If that were true, I would expect to see a more consistent pattern from both product companies and non-product companies, because they would each have the same type of calculation that you're talking about.
Not necessarily, because a product company is a competitor. It's looking to protect its own revenue stream.
So, and I think,
yeah, we are
sorry.
but
Thank you.
Thanks
Thanks very much.